Good morning. A periodical question by my friends, subscribers, and other lawyers was how to dispute the will. I have already stated that will is between not intervivors. It is between the persons who executed the will. If not alive, then only the effect will. If the life is there, the will have no effect. If will is brought for effect, there must not be life to the executant of the will. First of all, you should understand this AR 2022 Tripura page 11 judgment is very helpful to know the facts of the case and how to defend, how to even without applying for a letter of probation or a letter of administration, you can straight away file suit or not. All this answer is available. Therefore, you see the section 34 and 38 suit was filed stating that they are the owner of the property on the strength of the will. So even without going for a letter of probation or a letter of administration. So that consequential injunction restraining the defendant from interfering with his peaceful possession. So the ratio was number one, that the will was executed and the suit was filed off late, delayed. The claim of the plaintiff was the will was handed over to his wife and the wife in turn handed over to the plaintiff, and the plaintiff who was an advocate clerk did not disclose that fact to the court. Another thing is there was no closing signature of the person at the end of the will. Another thing was that the will did not contain disqualification why the children and husband were not considered for the property. So that is called disqualification. You have to say qualification if you want to bequeath the property, under what circumstances you are bequeathing party, especially to that person, and if you are not mentioning about all existing legal errors, you have to say that why you are choosing this person qualification, why you are not choosing that person, which is disqualification. This is also, there was no disqualification. Therefore, they have dismissed the suit. And second appeal was also dismissed. If you go through the entirety of judgment, then you can definitely understand the case. AR 2015 SC was also followed that. Another thing was they have categorically held that once a will is produced before the court, this will should be considered as in suit whether that will was not executed beyond suspicious circumstances. That is the primary thing. You have to prove beyond all reasonable doubt that the will was properly executed. That concept was introduced. Evidence Act 68 was discussed, and also Indian Succession Act 63 was also discussed, specifically by 34 and so many things you can understand with the judgment if you want to defend the will, and if you want to claim the property through the execution of the will. Okay, best wishes.